sure he's a Walking Dead fan, probably. So without any further ado, please, Jeremy, come on up here and give me the signal.
I think, okay. You guys can hear me okay with the lapel mic? Okay. I can shout also. So there's a couple different things I wanted to talk about tonight. As was mentioned, I've been with Pacific Legal Foundation for about a year. I focus on property rights and administrative law. Those are really my two big areas of interest. So tonight I wanted to talk a bit about property rights and kind of some of the overlap with this administrative regulation, the high costs of all the regulation that's currently going on. Because really property rights and regulation is very closely linked. So many of the restrictions, so much of the cost of these actual, is that too much? Can we turn it down just a little? Okay. Yeah. I can use that instead if that one's better. Either one's fine with me. Let's see, is that better?
I don't hear you. You got to turn it on.
Hello? This one again. There we go. Anyway, so many of these restrictions come in the land use context, restrictions on how you can use your land, what productive use you can put it to, whether or not you're able to use it. Oftentimes that also gets into business use. Of course, there's also a ton of regulations on how you're able to engage in business, which is another huge cost. Now, it's very difficult to accurately gauge the full cost of all this overregulation, but there's a really interesting study that came out just a few years ago by the Mercatus Center. And the way they tried to envision this, if you imagined all regulation had been frozen in place in 1980, and then looked at the world in 2012, and you compared this 1980 regulated 2012 to the 2012 that we were actually under. And what they found was that the size of the economy was about a 25% difference. So under all of the changing regulations that took place from 1980 to 2012, the economy was about 25% smaller than it would have been. So there's a few percent per year growth that didn't take place. It varied year to year, but in 2012, 25%, that represented about $4 trillion of a smaller economy than we would have had in the absence of all this changing regulation. When you spread that across 330 million people, that's about $13,000 per person. I mean, that's a huge, significant amount for each person. Imagine if every person in the United States was $13,000 richer. So you can see just how burdensome these regulations are. Now, the good news is, over the last few years, this has really become, I think a lot of people are becoming aware of this. More and more people are talking about it, just how much of our lives, how much of this regulation is taking place at the hands of unaccountable bureaucrats from Washington, and that average people have very little say in. And people are starting to understand just how much that impacts their lives, how many things they're not able to do, how much of their land they're not able to use, and what they're not able to do with it. So again, the good news, what's going on right now? We've seen some deregulation under Trump. And obviously kind of one of the first visible things was this sort of 1 in, 2 out executive order that came out on January 30th of last year. And that means that, many of you are probably familiar, but it means that if they make a new regulation, okay, you can put a new regulation, a new regulatory burden, but it has to be cost neutral. And the way you make it cost neutral is you have to get rid of 2 regulations, and the lessening burden has to cancel out the increased burden that you have. So ideally, the cost of regulations should not be getting worse. And just that would be a tremendous victory. And of course, as the regulations are coming out, 1 in, 2 out, just the number, lessening the number of regulations that your average person is expected to know and comply with would be a wonderful, advantageous maneuver. One of the other things that has happened under the new administration, and this is something that's been very important to Pacific Legal Foundation is use of the Congressional Review Act. And have you guys heard discussion of the Congressional Review Act before? I'm seeing some yeses. So actually a Pacific Legal Foundation attorney, Todd Gaziano, was one of the original architects. He was one of the drafters of the Congressional Review Act. This was a bipartisan act that was passed in 1996. And what it does is, so as was mentioned, I believe the whole activity is unconstitutional. Congress should not be able to give regulatory authority to administrative agencies. Fact is, under our Constitution, there's only one branch of government that is competent to pass laws, and that is Congress. But as we know, there's an administrative state, and they're passing all these regulations which act a lot like laws. They bind citizens and businesses. They can impose both civil and criminal penalties. They're very much like laws, but for the purposes of this, I'm not going to call them laws. They're in fact regulations. They're supposed to be implementations of laws that Congress has passed. Now, what the Congressional Review Act allows is that it at least takes back a little bit of power for Congress. It says, okay, we're giving all this regulatory authority to agencies, but what we want to be able to do as Congress is if you pass a regulation and we don't like it, we should get a chance to say, nope, not a good regulation, and they can pass something that's a resolution of disapproval. If they pass that resolution of disapproval, they pass it in the same way they would pass any other law. It has to go through both houses, then it's presented to the president who signs it, and at that point, that regulation is off the books. There's something even better about it, and that is that the Congressional Review Act also says if a resolution of disapproval is used and a regulation is taken off the books, the administration or the administrative agency may never pass another regulation that is substantially similar. So there's some question, what does substantially similar mean? To date, there's never been any cases that interpret that. So I anticipate, though, we might see some in the future because, again, on the good news path, so far 15 rules have been rescinded under the Trump presidency. So we have 15 rules that were on the books. These are major rules that had a huge impact on a lot of people. They've been wiped from the books, and the administrative agencies who had passed them during the Obama administration are not allowed to pass a substantially similar rule. Now, kind of the limit on Congressional Review Act is you have 60 legislative days from when those rules are submitted to Congress and the GAO, the Government Accountability Office. But here's the great thing. It turns out administrative agencies, I don't know if it was just being lazy, hard to say, they have not been submitting these rules to Congress. So even though the 60 legislative days from all rules that were passed at the end of the Obama administration has passed, at this point, there are potentially thousands of rules still out there that have never been submitted to Congress and that have never been submitted to the Government Accountability Office. This is another area where we think we're going to be able to help the administration, hopefully, make some inroads against the administrative state and get rid of even more rules. One good number of those thousands of rules that have not been submitted, the Brookings Institute did a review, a survey of those rules, and they found 350 of them, I think 348, but almost 350 that were major rules. And a major rule is a rule that has a regulatory impact of over $100 million. So that means there are 350 rules, each of which has an impact of greater than $100 million on American citizens and businesses that have never been submitted, and we believe that means they are not lawfully enacted. Any law passed after about September of 1996, in order to be lawfully enacted, has to comply with the Congressional Review Act. We've got thousands that haven't complied, 350 which are major. We believe that means that what we're hoping, in the coming year, you'll see some lawsuits where people start to challenge those laws. So if a business or an individual is subjected to a civil penalty, and it turns out that law was never submitted to the GAO or either House of Congress, they should not be subject to that penalty. They should be able to challenge it as unlawfully passed. We think that's going to be really great. Now, if we get some of those lawsuits and some of these laws start being struck down as unlawful, that gives the administrations a kind of a choice. Do they either not enforce the regulations that they have on the books, or do they now submit them to try and make them lawful? And if they do submit those laws, that starts the 60-day legislative clock. So we're also hopeful that some of these agencies, in an attempt to comply with the Congressional Review Act, will now, after the fact, even though it may have been several years since the regulations were originally passed, they'll go ahead and submit these to the Government Accountability Office, submit these to Congress, and that will give our current Congress and President another chance, another bite at the apple to get rid of some more of these regulations that are so tremendously burdensome. I'm sure many of you also saw today, this is just sort of a side note, not really about regulation, but also President Trump today did the reduction of the monuments in Utah. The Bears Ear was reduced from 1.3 million acres to only 228,000 acres. That's still 250,000 acres too many, but it's a really good, still a really good move. And the Staircase Monument was reduced from 1.9 million to about 1 million acres. So again, it's great to see the current administration making some of those changes, giving this land control back to the states instead of having federal control over it. So at this point, what I'd like to do is just kind of talk about some specific legal foundation cases, some of the important cases that we have, both in the property rights and regulation context. Although the first one that I want to talk about doesn't quite fit into either of those categories. It's actually a free speech case, but I think it's going to resonate with the group here, and that's a case called Minnesota Voters Alliance v. Mansky. This is a case out of Minnesota, and it was just accepted by the United States Supreme Court. They granted certiorari on November 13th. This is a free speech case, and what it is there's a Minnesota law that broadly prohibits any material designed to influence and impact voting or promoting a group with recognizable political views. That encompasses shirts, buttons, whether there's any reference at all on the shirt or button to a particular candidate or a particular issue that's actually appearing on the ballot. And the officials in Minnesota have interpreted that language exactly that broadly. They're saying that any shirt that expresses a general social or philosophical outlook is banned from the polling station. As the government has even admitted when they argued this case in the circuit, they said that it encompasses any shirt even with like a logo of the Chamber of Commerce, for example, or a labor shirt from the AFL-CIO. But our particular client, Andy Sillick, who's the executive director of the Minnesota Voters Alliance, is also a Tea Party member. And in fact, in 2010, he was turned away from the polling place when he showed up in a Gadsden flag shirt captioned "Don't Tread on Me," wearing a button that said "Please ID me." Those are the only things that he wore to the polling station, and he was turned away for wearing political apparel, and that was prohibited. So the Supreme Court just granted certiorari. We believe that they granted it because they'd really like to reverse it. I think we have a really good case there. Certainly such a broad, even though the Supreme Court has upheld some restrictions on the polling place when it looks like coercion, this is not coercion. This is people wearing a Tea Party shirt to the polling station. Another case that we have, which is here in Northern California and impacts a tremendous number of counties, is California Cattlemen's Association, and this is one that we're bringing against the U.S. Fish and Wildlife Service. And as many of you know, the Fish and Wildlife Service implements the Endangered Species Act. And part of what they do when they try to protect species, once they've been listed as either threatened or endangered, is they designate critical habitat. And critical habitat is defined as land that is critical to the existence or conservation of the species. And in this case, there's about 1.8 million acres of land that Fish and Wildlife Service has dedicated as critical habitat. It stretches across about 16 different counties here in California. And it's to protect the Sierra Nevada yellow-legged frog, the northern population of the mountain yellow-legged frog, and also the Yosemite toad. Now, there's another act. I mentioned the Congressional Review Act earlier. Now, in this case, and as I said, this is the case that Pacific Legal Foundation has brought on behalf of the cattlemen and also the northern wool growers. We've challenged this one under the Regulatory Flexibility Act. And this act is yet another of those laws that kind of understands just how burdensome regulations are. So what the Regulatory Flexibility Act requires is, whenever these agencies pass a massive regulation that's going to have a bunch of effect on average people, they have to consider its impact on small entities. So they have to take a look at small businesses and they have to say, if this is going to be hugely burdensome on small businesses, what alternatives do we have? How can we help out those small businesses? How can we relieve some of this burden? Now, it's not a perfect law. It doesn't mandate any particular outcome, but it does at least require that these agencies look at the different alternatives. And they have to kind of present them. They have to put them forward during the notice and comment period. And that then, including up to things like exempting, for example, small businesses. So you might say, well, Weyerhaeuser can certainly absorb the impact of a ban on some amount of logging, but a smaller family operation with a few hundred or a few thousand acres might not be able to absorb the same burden, so we're going to give them a waiver. Now, Fish and Wildlife Service takes the position that when they designate 1.8 million acres as critical habitat, which I don't know how familiar you are with the Endangered Species Act, the restrictions on your land, if it becomes designated critical habitat, are very severe. You have very few uses that you can use. It's going to be very difficult to make productive use of your land, very difficult to build, use in any way that's going to disrupt habitat. The standard is something they call a take of an animal, and a take of an animal does not mean where you actually kill the animal. That can mean if you harass the animal in some way. Harassment qualifies as a take, and that can be subject to severe civil penalties. But FWS says, yeah, we know this Regulatory Flexibility Act exists, but we don't think it applies to us. And their reasoning is, well, they're not actually putting a restriction on your land. What they're doing is they're putting a restriction on government, other government agencies, telling them that they're not allowed to allow you to use your land. So because they're restricting other agencies instead of people directly, they think that they don't even need to consider the burden of this impact. Of course, we consider that to be wrong, and that's why we've challenged it. In fact, the Small Business Administration Office of Advocacy agrees with us. They've also filed briefs saying that critical habitat designations have direct effects on small businesses, which should be reflected in Fish and Wildlife Service's regulatory flexibility analyses. Advocacy encourages the service to review its cost impact estimates and to consider the current state of the industry when determining areas that can be excluded from a critical habitat designation. So we're very hopeful that this will at least put another roadblock and another requirement for Fish and Wildlife to consider what they're doing and what those impacts are of critical habitat designations. I have another case I'd like to talk to you about that, just to kind of let you know how amok Fish and Wildlife Service has gone. And this is one that's out of Mississippi, and it's called Markle, also against Fish and Wildlife Service. Now this one involves the dusky gopher frog. And I believe it's about 12 or 1,600 acres of critical habitat. Our client is someone named Markle Interest, they're a business, and this land of theirs is now designated critical habitat. That represents about $34 million in lost profits to Markle Industries. So this is, a tremendous burden that's been placed on one single individual. All of the land that's been designated for this dusky gopher frog, the only land that has been designated in the United States, is on Markle's property. And as I said, this is a tremendous burden being placed on one single person. But here's the really crazy thing about this critical habitat designation. There are no dusky gopher frogs on Markle's land. Not one dusky gopher frog. Oh, just wait. Not only that, there has never been a dusky gopher frog on the Markle's land. If ever, the best that the service can say is that perhaps there has been a dusky gopher frog about 60 or 70 years ago. If tomorrow, one of the, let's say a Fish and Wildlife Service, a rogue agent, were to go find a dusky gopher frog, carry him to Markle's land, and drop him right in the middle, the dusky gopher frog would not survive because, in fact, none of the 1,200 acres that has been designated is suitable habitat for the dusky gopher frog. And Fish and Wildlife Service has contended that because With future intervention, the land could be made to be a habitat. They're allowed to designate this as critical habitat for the dusky gopher frog. And as I said, the definition of critical habitat is essential to the conservation of the species. So, based on nothing more than the statement by some government bureaucrats that maybe one day somebody will come along and decide that they want to make this dusky gopher frog habitat, they've pulled 1,200 acres away from this, again, a single business. It's a family-owned, but a corporation, a single business that represents about $34 million in lost profits. That's jobs lost, so much productivity lost, and based on nothing more than just this statement by a couple of government bureaucrats from Fish and Wildlife Service. Now, one of the other big problems of this is the fact that the courts defer to statements by agencies like that. That would be a whole talk in and of itself, but that's what happened in the lower court. The court said, well, you know, it seems like it can't be critical habitat, couldn't be habitat for this frog, but the Fish and Wildlife Service tells us that maybe one day it could be, and we're going to go ahead and defer to that. We're going to just go along. Too often courts have been rubber stamping whatever these agencies say in court, even when it's completely unreasonable, which we think this is. So this is one that we're now, again, petitioning the United States Supreme Court. We're very hopeful that they'll accept this case. The facts of it are just so outrageous, I think it's certainly a good case for review. Let's see here. I'll talk about this one. This one's a little bit different. This is a Fourth Amendment case. Well, Fourth and Fifth Amendment. So as you might know, the Fourth Amendment gives us a right to be free from unreasonable searches. And the Fifth Amendment gives us a right to be free from takings of our property, or more specifically, it requires the government to pay us just compensation if they take private property for a public use. So here in Scott Township, Pennsylvania, we have a lady named Rosemary Nick, and she has some land, I think it's about 80 acres, and she's had it for a very long time. But there are some people who think that perhaps on Rosemary's property, again, this is Pennsylvania, people have been living there for a long time, there might be some burials, basically family burials that have taken place on her property. And that's very common back there. There's no, I think even to this day, you can do a backyard burial in Pennsylvania and there's no law against it. But the local government passed a law that says government officials are allowed to go on anyone's land to look for what might be one of these old burial grounds. And if we find it, we are then going to basically give you a notice that says you're required to open this burial ground up to the public. You're required to give public a right of access so that if it's a family plot of people who have long moved away, they have a right to come see this burial ground of their ancestors. So, yes?
People read the Constitution?
Unfortunately, I often wonder when you talk about constitutional law, that is the unfortunate part about it is that so much of it is pretty far afield from the Constitution. And, the really interesting issue in this case is something that has no basis in the Constitution. And what that is the court hasn't even listened to Rosemary Nick's claims for violations of her Fourth and Fifth Amendment rights. What they have said is, Rosemary filed in federal court, and they said, there's this case called Williamson County, and if you're going to ask us about a Fifth Amendment property taking, you have to litigate in state court first. And you have to litigate all the way up through the state Supreme Court, asking the state to compensate you. And only then, when the state Supreme Court doesn't compensate you, can you go back into federal court to file for a Fifth Amendment violation. So there's no basis in the Constitution, and there are no other constitutional rights that are subject to that type of a limitation. So this is a case that PLF has long been trying to overturn. We've had a lot of success of creating exceptions and limitations and getting some very good language in various courts saying this is prudential. In other words, courts can ignore this case if they want to. But really our goal is to get the United States Supreme Court to say that. We want them to say either this doesn't apply to facial challenges, these types of challenges, or you know what, this case was an entirely bad idea and we want to overturn it. So this is also a case that's on petition to the United States Supreme Court, and we are very hopeful that they will accept it and finally overturn Williamson County. Just to talk about a few, I'm sure everyone here is fans of the California Coastal Commission, right? You know, there's just so much going on there right now, and I don't have a particular case that I really want to talk about on that, but just to give you some ideas of things to watch out for right now. If any of you, you know, are also subject to coastal properties, right now the California Coastal Commission is trying to make a fundamental change to the Coastal Act. They've been trying for years. They just had another bill shot down earlier in the year. In fact, I went and testified against this bill. They're trying to change the meaning of existing structures. So the Coastal Act allows anyone who has a property with an existing structure to get shoreline protection. That means if you're along the coast, there's flooding, for example, your bluff face is collapsing, you're allowed to build a seawall. And the California Coastal Commission has been trying to change the interpretation of existing structures to only mean structures that were in existence on January 1st, 1977, when the California Coastal Act took effect. As recently as 5 years ago, the Coastal Commission was admitting in court documents that they had never interpreted the Coastal Act in this way. They are now trying to require cities to adopt language in their local coastal plans that makes this fundamental change because they haven't been able to do it the proper way through legislative action. So that's something to watch out for. Just coming next week, I know the city of San Clemente has been fighting the California Coastal Commission, trying to prevent that change in their local coastal program. And the Coastal Commission was refusing to accept or to certify their local coastal program unless they make this change. So they failed to do it on their own. They failed to do it through the legislature, and now they're trying to force cities to be the bad guy and adopt this new regulation. And the last case I want to talk about today, of the ones that I have prepared, is one that I filed, so it's very near and dear to me. And that's in Marin County, and it's our client is Willie Benedetti, and he's a turkey farmer. And in Marin County, again, this is the Coastal Commission. These are the local coastal program amendments, and they just adopted a new land use plan. And the land use plan in the agricultural zone requires, if you build a dwelling, any sort of a house, you must make a promise to the county of Marin. And that promise is, I as a landowner will be actively and directly engaged in agricultural use of my property at all times. And if I'm not involved in active and direct agricultural use of my property, I'm no longer allowed to own that land. And so the client that we have, Willie Benedetti, he's a turkey farmer. He sells about 50,000 turkeys a year through Williams and Sonoma. You know, I mean, this is a guy who has been a huge benefit to Marin County. He's, you know, his name is known nationwide. He sells these turkeys everywhere. A great guy. He's been a huge part of the community. And, you know, he has an adult son, and he'd like to build a house for his adult son. He's got a couple of grandkids. He'd like to put them on his property in a new house. And then he'd like to just step back a little bit. Not really, maybe retirement, maybe not, but basically just enjoy kind of the fruits of his labor. Enjoy his grandkids. Enjoy the land that he's had, as I said, that he's been working hard for about 50, 60 years. And, you know, this new ordinance gives him a choice. He either builds this house and then continues working forever, or he doesn't build the house, or he builds the house, and as soon as he stops working, he has to give it to someone else who is working his property. We think that's totally unconstitutional. So this we filed just in July. I'm very hopeful, again, that we'll get a good result in this. This is down in Marin County Superior Court, and we're just waiting. Probably in the next couple of months, we'll have our first case management hearing in that case. So that's all of the cases that I've prepared, all the things that I wanted to talk about. So at this point, I'm happy to answer any questions that anyone has. Yeah?
If you have a question, please go to the mic.
Oh, mic over there.
I understand. I understand that there might be some attempt to take possession, the state take possession or control of underground water. Is that something that you're working on?
Yes. You know, I am familiar with that, and that's, California water law is tremendously complicated. But, and I don't know if any of you have heard of the public trust doctrine before, but that's been the real big push right now. And in Siskiyou County, there's a case that just came out about, I'd say, I think the decision is just only maybe a month or two old, a few months old. It's on appeal, and I expect it will continue to be appealed. But essentially, that does expand public trust considerations to the use of groundwater. That's in addition to, of course, the comprehensive water laws that California has passed over the last few years, requiring the water management districts and things like that. I'd say right now the big battle is the public trust doctrine. If that goes forward, what that means is anyone who uses groundwater that is hydrologically connected to a navigable stream, to some sort of, which, you know, it's fact intensive, and there's areas all throughout the state that, you know, I think there would be a battle over just what counts as hydrologically connected in that particular location. But that would basically give environmental organizations and you know, especially environmental organizations, a hook to challenge any sort of local groundwater decisions. And I think that's probably one of the big issues. That's the biggest issue right now. But yeah, of course, I could also see California, even with the fairly comprehensive groundwater laws that just you know, are only about 3 to 5 years old, I could see them trying even more. The only states, I will say, the only states where there's been a full kind of groundwater grab of that nature are states where they've passed a constitutional amendment, and I think that California might have to do something similar if they were actually going to take full control of all groundwater. But you know, it would be a battle in the courts either way, I think, because obviously it is a property right. Your reasonable use of your groundwater is a property right that has a long basis in California law, and that would constitute the government taking it. Yeah.
Is there any way for us to fight these idiots? Okay? I mean, I'm just a normal guy out here, and I get so tired of hearing what the government wants us to do. The government is supposed to work for us. Why are they telling us what to do? I'm kind of fed up. If somebody comes up to my property and says, hey, we're going to take over your water. No, you're not. I'll go to jail first or I'll die, but I'm getting tired of them telling us how to live our lives.
Yeah.
And how do we get rid of this? I mean, these people need to go. The environmental people need to go. How do we get rid of them?
Yeah, you know, it's such a multi-pronged attack. I will say that, you know, I made my choice in going to law school and working for Pacific Legal Foundation, that I'm hopeful I can have some part, you know, some small part working on the edges of the law, trying to make these changes that are going to help rein in some of those abuses. But, you know, the large fundamental changes are almost always going to have to come from changing public opinion.
My thing is, like, the government's supposed to work for us.
Yeah.
You want to pass a law that affects us, that makes us, that's up to us. Let us decide whether we want to or not. Why are they always telling us what's better for us? They have no idea. I don't even know them people. How do they know what's good for me? And I'm really tired of all of this. There's more
things that people are throwing down our throats that are unconstitutional in the first place, but yet the lawyers turn around and they go, you know what? I'm tired of lawyers.
Me too.
I'm tired of the government that has been running this country
Yeah.
into the ground. And I think the people should have a voice to say, no, you're not gonna do this.
Yeah.
You don't have to have billions of dollars and state all this. Our Constitution is supposed to protect us against that stuff. So how are we gonna do out here? If we do anything. Excuse me?
Yeah.
The best thing you can do is encourage your neighbors to support organizations like BLF. They're working to make those changes happen. Then we can pay attention to who we're electing.
Yeah.
Real attention.
And I believe that, like I said, a lot of these fundamental changes happen in a lot of areas at once. And the reason is that when, politics follows, politics follows culture also. Yeah, yes, the money, I agree, but politics follows culture. It's downstream of culture, and really the law is also. And so, excuse me, what makes my job easier is when there's massive public sentiment and support for the ideals that we are advocating in the courts of law. Because when judges aren't immune from public sentiment, and they get a sense of what's going on, they know that when there's popular support for real constitutional protections, they are also going to make decisions that reflect that culture. So, as I said, I think it's a multi-pronged. I think that the best thing everyone can do is be persuasive to everyone that you meet and talk to. Vote your conscience and vote principles. And meanwhile, I'll keep trying to advocate those principles in the courts of law, and we'll hope that the courts catch up.
Staying on the underground issue, up here in Loma Rica, 8 years ago, Yuba County came out and decided they were going to unlock the well. Approximately 8 years up here in Loma Rica, Yuba County, somebody from the Yuba County Water Department or somebody came out to the property, left the road, came onto the property all the way to the well house, and proceeded to try and put a lock on our well. So of course Dad happened to be looking out the window, and he took the shotgun and forced him off the damn property. They haven't been back since, but this was approximately 8 to 10 years ago. I don't suggest that, but it worked.
I take no position on it. Take no position on it. That's one interesting point is the fact that so many times when government, there's a former PLF attorney who refers to it as the permission society. And what it is once we've taken the kind of fundamental position that we have to seek government permission for everything we do, they then have the ability to leverage that permission granting authority. So if all wells have to be permitted by the government, and what government now does when you seek a permit for a well is they actually force you to give essentially an allowance. You have to allow people to come onto your property to inspect that well. You basically are agreeing to allow government inspectors. So one of those fundamental sea changes that I think needs to take place is this idea that there's no, we don't need permission for everything that we do in the world, for every use of our property, for every activity that we want to engage in. Yeah.
Yeah, I'm sorry, but you have a huge falsehood that you've bespoken. You use competent and Congress in the same sentence.
I fully agree. Could not agree more. As far as we assume that they are competent to do anything, which I think is always a huge assumption. At least I would like to see them in doing it within the constitutional limits that are set. And the more strictly that we enforce those constitutional limitations, I think the less things that, regardless of whether or not Congress is competent to engage in it, the less things they will actually be able to engage in or that they will believe they are competent to engage in. And again, that gets to that idea of this fundamental sea change of exactly how much regulation are we willing to allow our Congress to engage in? How many? I'm with you, but at some point, until we start from the assumption that they can't micromanage down into the smallest aspects of our lives, they're going to keep trying to do it. And right now, that's where the big value is. People try to push for nationwide legislation. Why legislate in your local county if you could instead get nationwide compliance with whatever it is you wish?
Well, I'm going to attack this from a different direction. Do you people remember that song about the billy goat that hit the dam so long and it broke it? The billy goat can? Frank Sinatra sung it. Well, here's my idea on this whole thing. The lady with the 80 acres, she should put a fence around it, put up posted signs. Anybody caught on this land will be shot or taken to jail. Okay. Now, the Supreme Court ruled that the most powerful man in the state are the 58 sheriffs. They have absolute power over everything that they want to contact with. Okay, she could go to the local sheriff and say, I protected my land. The sheriff would have the authority to arrest anybody on that land. Now that's one thing. Now to prove that we have the power to do this, the Supreme Court lady who was the Chief Justice a few years ago had the audacity to say that a woman, when she was raped, did not suffer any consequences. The people of the state of California kicked her butt out. We also threw a governor out because he was doing things that we didn't like. Well, we have a governor right now that's an absolute dictator.
Even the tater out there.
But to show you how upset I am about it on the whole thing, is the gross national product of the whole world is $60 trillion. We are $22 trillion in debt right now. Now, I have brought this up with the Sutter County Supervisor. I've mentioned it at other places. And they also, what the hell can we do about it? What we can do is put our money where our mouth is and get some help like this gentleman right here and think up some ways to get together and throw them out. And we'll start with these people that are running our county and our city right here.
Amen.
And just to give you a little idea how far I go back in this, my wife and I went to Valley Forge. There is a center there where you can check if you have any relatives. I checked. Guess what? There was about 8,000 troops there with George Washington. I checked my wife's name, Dodge. 21 Dodges were with George Washington. I checked my mother's name, Tackett. There was one Tackett there. I checked Miles. Miles had 22. Now that's a whole lot of people in two people. When it happened 200 and some years ago. And I think we ought to be like those people at Valley Forge. Stick to our guns and get this straightened out before we become a total third world country. Thank you.
When you go to court against the fishing game, are you allowed to present petitions signed by the people to argue your case?
So so generally with the way that we're challenging it, no, that wouldn't be something that we do. But I would say that one other thing that is always valuable or can be done by people is looking at the Federal Register, which is the least exciting thing you could ever do. I fully admit. Whenever they take these sorts of actions, whenever they impose a critical habitat designation, whenever they list a new species as threatened, this goes for every single federal agency, not just Fish and Wildlife, they must publicly announce it through something called the Federal Register. And they must leave it open for people to submit comments. And that's one of the best things that can be done, not least of which for the reasons that when people submit comments, that makes them potential plaintiffs down the road.
Yeah. So it's supposed to be power of the people. So if we can't even go there and express our thing, what power do we have?
Yeah, like I said, I think there's a fundamental problem with the entire assumption of the system with this from the idea that everyone's getting notice. All the people impacted by a regulation are getting notice. Again, like I said, how many people have looked through the Federal Register? As I've said, it is thousands and thousands of pages, tens of thousands of pages per year, as boring as you could possibly want. But when you look at the total amount, the Code of Federal Regulations is about 100,000 pages. So all of these regulations that are, the 87,000 pages a year of Federal Register, that gets distilled down into all these Code of Federal Regulations. There's 100,000 pages of regulations that get treated like laws. There's no hope for your average American. I think I can say this with confidence. There's no one person who knows the entire contents of the Code of Federal Regulations. There's no one person who can state with absolute authority what it would take to be in compliance with all of
Chris Van Hall come close.
Yeah. So, but the point is, we've allowed the government, the federal government, to pass so many regulations, micromanaging so many aspects of our lives that we're at a point where compliance is impossible.
Why don't the facts don't mean nothing in these courts anymore? The judges ignore them, they all ignore the facts.
Yeah. So,
like maybe one frog in a million acres, that's a fact.
I know. Yeah, what's especially unfortunate is that, as I said, right now there are doctrines of deference. And what that basically means is when we go before the court and we're challenging something that an administrative agency has done, if they've got a little bit of evidence, it's good enough. There can be a bunch of evidence against their position, but if they've got a little bit, it's good enough. And I will just say this is one of those things that I think we're still at the kind of leading edge of it. It is a sea change in idea of whether or not this is a good idea. Throughout the 80s, ideas of deference were very popular amongst judges and amongst even conservative legal minds. And the reality of it is, it has allowed administrative agencies to take huge amounts of control, and courts have just said, we defer to this interpretation, we defer to your judgment. And the fact of the matter is, it's the job of judges to judge. And they should not be passing off that judgment to an unelected bureaucrat who sits in Washington from administration to administration and is not politically accountable. So I think that it's a process, and we're going to continue attacking that. We're not the only organization who's attacking it, but I'm very hopeful that in the next decade or so that those types of doctrines will start to get chipped back. And the more that those things, as I said, the more that those changes start to happen, hopefully the more that we'll go on and we'll get back to something closer to an original constitution.
So it would seem that ignorance of law is an excuse.
I believe it should be, because it's impossible to be all knowledgeable of the law. And frankly, to penalize people for minute, there's someone who wrote a book, I mean, it's called, I think, 3 Felonies a Day or something like that. The average American is committing felonies every day, and they probably don't even realize it. And the fact of the matter is, we're now at a point where if our Fourth Amendment search constitutional rights are not protected, government is going to be able to find a felony to charge you with. It's just a fact. They can scrape through your information without any sort of a warrant. The stuff that you've placed online, the phone that I've got in my pocket, it probably contains enough information to find some sort of felony. Exactly. And once they've pulled you in, they find a felony, they put something in front of you, and eventually people, take a plea, agree to something else. So.
Flynn's a good example.
So,
Yeah. And Flynn is also a great example of, well, A, don't talk to the police or the FBI. Shut up and get a lawyer. But B, definitely don't lie, because you will get caught in that lie. And, really, the conversation itself is not even a crime, but lying to the FBI is a crime.
I don't know if you're familiar with Fred Kelly Grant and the acts of coordination that the federal government must do with local government in order to not infringe upon the economy, the local economy, or the wherewithal of its residents. Is that something that PLF would encourage?
Yeah, we have the case right now in the Ninth Circuit out of it's Plumas National Forest, and that's specific to that issue where there's essentially they've done a land management plan within the forest as to the trails, motorized trails that people have used for decades for motorized recreation, ATV vehicles, off-road motorcycles, things of that nature, and they've closed down a large number, the vast majority of those trails over the last couple of years. And actually, we are bringing a lawsuit specifically on that coordination issue because they did not coordinate, or more specifically, they didn't coordinate with Plumas County any more than they would have with any other individual. So basically, that whole notice and comment procedure that I discussed with any other regulation, they said, well, we allowed the county to engage in that, and that qualifies as coordination. So we have a pending case on that saying that, whatever coordination is, it's not the same thing that everyone else gets. Why would Congress even pass a law requiring coordination if that was all? So we're, again, we're hopeful on that. Hopefully we'll get that's going to be argued in February. And that also nicely presents this idea of deference, because they've said, essentially what the service says is, whatever we say is coordination, and the court just has to defer to our interpretation of what it means to coordinate. So that also puts forward that issue nicely of deference that we'd really like to bring up to the Supreme Court.
Jeremy, how enthusiastic is PLF for the current appointees to the federal court, and when will we start seeing results?
That's also, I can't believe I didn't write that in here anyway. No, it's been fantastic. If there is, I think, for most of us at PLF, that is hands down the single greatest thing that has happened in this administration so far. Justice Gorsuch is just a phenomenal justice, and that's to say nothing of the numerous appointments that have taken place on the circuit courts, in the district courts. I'm especially pleased with the appointment of my colleague Damian Schiff, who's actually a PLF attorney and was appointed to the Court of Federal Claims. I think he's going to be a fantastic and excellent judge. But really, that's been just fantastic. I think that it will take time, but and I don't have the most current numbers, but as of about March or May, early on in the kind of appointment process, I think there was about 138 open positions on the federal judiciary, and that's it's something like 20% of potential seats that either are currently open or are likely to become open over this first 4 years. And if President Trump is able to make those appointments, that encompasses judges can take senior status. If they take senior status, that opens up the spot on the judiciary for a new appointment. If that takes place, I think we could see some of these big changes like deference doctrine starting to take place. And of course, what would be really exciting for us would be if President Trump gets one or even two more appointments to the Supreme Court. That would be huge. It would certainly strongly solidify, if they're in the mold of Justice Gorsuch, I think some of these arguments against deference and against the administrative state start to become a lot more plausible in terms of actually getting 4 or 5 votes on the Supreme Court, which could signal, again, a big sea change for constitutional law, which would be fantastically exciting.
So, the PLFs, are they really active in the Constitution?
Well, I mean, the vast bulk of our cases, we bring under constitutional theories, so, yes.
I mean, as far as I'm concerned, looking at history, Franklin Roosevelt overstepped his bounds. I mean, he was in there for 4 terms. I mean, and he took his authority and corrupted our Constitution. Since the government right now is on the 60-day trial, they got this hanging out, there's just slip up bill saying, hey, we're going to shave off the last 17 amendments. Because that right there is the complexity of all these things that are happening right now. If we stuck to our original 10, nothing this would happen.
Yeah.
That gentleman right there is the right idea. And we need to go back to our first 10, forget about that 11 through 27, because it's all about economic control. We were thriving, this country was strong, and you know what, because of that, the government thought they'd step in and start regulating people's lives. That is not that's dictatorship, that's socialism and communism.
Yeah.
And we should have stopped it right then. We should have stopped the 10 Commandments being taken out of the schools. But, I mean, hey, let's slide that 60-day on.
Yeah, I mean, I definitely, it'd be more than just that. The other big thing that we have to contend with is the Commerce Clause. The interpretation of the Commerce Clause is the single verse. That's, everyone may not realize this, but basically almost everything Congress is doing, the vast bulk of what they're doing is enacted under the Commerce Clause of the U.S. Constitution, which just says that Congress is allowed to regulate commerce between the states. And of course, you have to wonder how much of those things qualify as commerce. And there's been a few constitutional limits placed on it by the Supreme Court, but it's shocking how much Congress is willing to claim is commerce. And it goes to, there's a very famous case from the early 20th century where wheat grown privately for an individual on their own land was found to be interstate commerce, because if everybody grew their own wheat privately on their land, it would drive down the price of wheat for people who are selling wheat in interstate commerce. So if you start from the idea that Congress can use that sort of an attenuated effect to regulate things in our life, there's not much of a limiting principle. And that's, again, that's where we hope things will start to go. These beating back on broad interpretations of congressional power would be a huge start. Once we rein in the idea that Congress can regulate everywhere, we can start having the conversation of where are the important places that they do regulate.
Jeremy, are you familiar with the State of Jefferson movement?
I am. And in fact, if anyone's going to the, I think the annual meeting in February, I'm actually going to be speaking there too. So you may see me again. I promise it will be a different talk.
So you're familiar with their lawsuit they're attempting to
Yes, yeah.
engage in?
Yeah, actually, I can't remember the gentleman's name, but I have seen the complaint. I've read through it. So, yeah.
Mark Berry.
Yes.
Do you think they have a chance?
It's a difficult case. I'll be honest. It's a difficult case. I'm never hopeful with constitutional law is difficult, but I should say I'm always hopeful. I'm always unreasonably hopeful, but it's a difficult case. It will be interesting to see. I will definitely be keeping my eyes on it. It's kind of outside of my area of expertise. So I've read it, but I don't know much of the kind of legal theories to speculate, or enough on the legal theories to speculate.
Okay, are we all out of questions? Nobody's got any lingering?
Where do we get our guns?
Oh, and I will just add, I threw a bunch of business cards on the back table. Normally I have something to sign up and get updates or things like that, but on the card, pacificlegal.org, pacificlegal.org, you can sign up and follow all of our cases. We've recently redone the whole website and it looks fantastic. So please grab a card, and if anyone has further questions or wants to reach out to me on anything, or if you have government messing with your property, please reach out to me. Always interested.
Thank you.
What's that? I did not bring my guitar. But is there another question?
Well, not a question, just a subject that I just want to bring up to you and see what you say. If you would have any oversight on it or have any ability to challenge it. But first of all, a positive slant on the Department of Water Resources Board. I know a lot of people, there's a lot of contention about what's happened with the Orville Dam situation. But let's just say they did a decent job in the, can't even think of the name, who did the work on the levees? Somebody help me. No, who did the work on the levees? The government. No, just, I can't think of it, it's not the Bureau of Reclamation. Yeah, there's some from the Bureau of... No, it's not the Bureau of Reclamation. Anyway, reclamation is a subject.
Army Corps of Engineers.
Follow here. The basin of the Feather River between, the levees has been a problem of concern with those that are interested in it for years. And by that I mean they allow foliage to grow there without any hesitation or without any general prevention because, the government says it has to be left alone, let's put it that way for simple words. Also, they come in with various, if you want to say agencies, come in and grow agricultural products in the basin. Now, the time that I had a chance to review that was about 5 or 6 years ago on a tour of the levees. And I was told at that time, I was riding along and I thought, well, this is kind of a dumb question. I looked at all this growth in the basin, and there's big trees growing out there, and they're protected, federally protected, that's what I was told. And what can you do about them? Well, what do you want to do with them? I said, well, it seems like they should be removed to allow better flow of water all the way down to the bay. And the district manager said, we can't go there. And I said, you mean you can't even suggest it? And he said, no, we can't even suggest it anymore. We have to let them do that. Now, with all the growth that happens in that basin, I said, what do you think it raises the water level on the river? And let's say that we've got a condition like we had in, I guess 97 or 86, either one, where you had the river going from bank to bank, and if it had risen maybe 4 or 5 feet more, it would flow over those levees that are supposed to protect us. So, I guess my question is can PLF address that situation, because there doesn't seem to be anybody that can do that. And I don't think the general public in this area, because I've been here 47 years, 45 years, I guess, but we've had a lot of newcomers that come into this area to live, and they really don't know, what's going on in that relationship. But if the water overflows the levee, they're gonna find out, and that's not a good consequence.
Yeah.
So I hope that I'm making myself rather clear that those are a restriction. And so I didn't mention it, but I will say now, I asked him what that restriction would cause in raising the levee, raising the water level. And he said, oh, I could make an assumption of 2 to 4 feet. Well, that's a big quantity of water. That's just not a small amount of water. And if that's what the water could raise over the levee, I think something should be done in respect to the basin. And the reason I went to Von Geldern and talked to them, because they go way back, and they said after 1955, they totally scarified the basin of the river. It was totally clean. He even showed me some pictures of it. But since then, they've allowed it to grow because of what a lot of people in here have talked about, government control. And it's just the agency isn't coming to mind, and they do all this work on the levee, and they supervise it, and they're controlled out of Washington. And so who controls what goes on in Washington? Sierra Club and all these, tree hugging groups. And they want all this foliage to allow to grow in the basin, which I think is absolutely ridiculous when we're trying to protect people from, again, their private property.
Yeah, I think
Said enough, but.
Yeah, no, I think that, one of the other, as I kind of mentioned, one of the other important principles that, and off the top of my head, I don't think I'd be able to make a guess or hazard a guess about the particular situation there, but ideas of federalism are very important. And one of the other things that we should be trying to encourage is state and local control, not federal control from Washington.
Right.
And so there's a very important case that was argued either today or I think today at the Supreme Court. It's Christie v. NCAA. And that is an important federalism case. That's about whether or not the federal government can prevent New Jersey from legalizing certain types of sports gambling. And this could be a very huge case, far beyond the gambling context, because the principles that are at heart is if a state wants to decriminalize or deregulate something, can the federal government step in and force them to continue regulating it? So I think that's something that we should be hopeful for. It sounded like the justices were very skeptical of the NCAA's position. So I think there's a good chance that we could get another strong federalism Supreme Court case out of this term, which, then in the following years, I think you'll see people start to try and apply that in more and more places. And that could be a very good development.
Okay, does that mean that GLF would take on that kind of an issue involving?
We're always interested in separation of powers and federalism principles or core PLF principles, so we're always interested in it. Absolutely.
It's my understanding that 3 months prior and 3 months after the 2012 election, Obama put in about 1,000 regulations, and total through 8 years about 12,000. Does that sound right?
I honestly
Spitting on the sidewalk,
Yeah.
just scratching your head going down the main street or whatever.
Yeah, but I mean, the difficulty in saying is, so essentially, once Obama was elected, he appoints the people, and then those agencies start to apply. I would have no doubt that there's been thousands of regulations during that 8-year period. I think 12,000 probably sounds reasonable. As I said, 80,000 pages or so a year goes into the code, into the Federal Register, which is from everything from executive orders to regulations that are being proposed, regulations that are being adopted, things like that, decisions that are made under previously passed regulations, as well as just guidances, those are the ones that are really difficult as guidance documents that just interpret regulation or purport to interpret regulation. So it's difficult to pin an exact number because it's difficult to say exactly what a regulation is under a lot of those contexts.
Court law and everything. I remember when I was a kid, if I wanted to get up a baseball game in a field, I'd do it. It didn't matter who owned it. If I wanted to cross over to the next street, I'd go through a vacant lot. It was my problem if I broke my ankle. And now everything's fenced. I mean, it's ridiculous.
Yeah, I agree completely. There's multiple areas where if I could command it tomorrow, I would make some changes in tort law as well, especially in California. It's just terrible. Very, very difficult to be a business owner or a property owner in California.
Okay, everybody got it filled? Give Jeremy a hand.